want to welcome the public protector and the legal team led by Advocate Mbofu, the evidence leaders, Advocate Bauer and Advocate Mayosi, members of the public interacting with this session, the media, and the entire support staff. Today is Tuesday, the 9th of July. We continue with our hearing of the witness, Mr. Tebogo Kekana. We adjourned yesterday at a point when Advocate Mbofu was continuing with cross-examination. Before I continue, just want to check first, Mr. Kekana, are you there?
Good morning, Chair. Yes, I'm here.
Thank you very much. Advocate Mbofu, are you there?
Recording in progress.
Advocate Mbofu, are you there?
I'm here, Chairperson.
I don't see you.
Yes, I'm just trying to put the video on.
Welcome, Kulu.
I'm trying to. Can you can hear me?
I can hear you.
Can you see me now?
You came out and then ran away immediately.
Okay.
Now I can see you. Thank you.
Okay. Thank you. Good morning. Good morning.
Good morning, Mbofu. So just before we commence, just to make a couple of comments, colleagues, that Advocate Mbofu will continue with the cross-examination, and I'm allowing to do that. And the plan is that between tea time and lunchtime, he would be finishing with his cross-examination. From 2 o'clock, it's a holy ground for members. So I need enough time for members from that point immediately after lunch to interact. I will at some point before members come in and ask the evidence leader to raise 2 quick issues before members come. So that's really the lineup for us for the day. I'm hoping Advocate Mbofu will be done by tea, but if not, we'll stretch it to lunchtime. Thank you very much. Welcome, everybody. Advocate Mbofu, I now recognize you.
Thank you. Good morning, Chairperson. Good morning, honorable members. And good morning, Mr. Kekana.
Good morning.
Yes. Chair, in case I forget, at 2, I'll also want to address you just on one small issue. But so if I forget, I'm sure one of my team members will remind me.
Thank you. Thank you. Go ahead, Advocate Mbofu. I had you.
Thank you, Chairperson. Now, Mr. Kekana, we were still at the place where, or rather, we stopped at the place where you were talking about, or rather, I was reminding you about the inputs from Mr. Niels van der Merwe. And you had said that he gave you some inputs both before and after the report. You remember that?
That's correct.
Yes. And in fact, it is correct that Mr. van der Merwe and you, or rather, you had been interacting with him in the process of the investigation. He came with you to APSA, for example. Is that correct?
to APSA.
Yes, when you went to APSA, was it not part of your, if you can remember, was it not part of the team that came with you?
I don't recall. I recall going there with to APSA's attorneys, you mean?
Yes.
I recall going there with Mr. Rodney Mataboge. I don't recall going there with Advocate
Mr.
Van der Merwe. Yes.
Okay, but he might have been there maybe because you were visiting the legal team.
Sorry?
I'm saying he might have been there. You can't recall, I accept that. I'm saying, but he might have been there maybe because you were visiting the legal team, the attorneys of the other side.
Yeah, I don't recall whether he was there or not.
Okay. Anyway, the point was really that you were aware that he was doing some research and he was providing some constant input. Hence, you say he gave you something before and after the report, correct?
Yes, PP did request some input from him on,
yes,
on a number of issues.
Yes. Now, and so the only issue really is it's not such a big thing. I just wanted did you get a copy of the paper that he prepared and sent to you?
Yes, I got it this morning. Right.
Now, do you remember now, and as I say, I accept that this was a long time ago, so when you couldn't remember this, I'm not holding it against you. But has that now jolted your memory as to the nature of his input?
Yes, I remember he sent a document of this sort.
Yes. And the only point I want to make of this is that that document was giving what one might call a broad economic analysis and a comparative study of different economic models in different countries pertaining to reserve banks. Would that be a fair summary, broadly speaking?
I'm not so sure. It looked to me, because as I said before, I'm not an economist, but it looked to me as if it was some sort of a comparative study.
Yes.
Just a pause there, Advocate Mpo, for a quick issue, Honorable Milham.
Thank you, Chair. I'm sorry to interrupt Advocate Mpo in his cross-examination, but we don't have a copy of this document. We don't know what's being referred to here. So I think that it would be useful if we could see that.
Yes, thank you. No,
thank you.
I'm sure the evidence leaders will put it up. Mr. Kakana got it from them because we sent it to them as promised yesterday, Chairperson.
Okay. Let's try and have that flighted.
If you can, if you can start just by putting up just the cover page, please, whoever is operating the system. Okay, Honorable Milham, can I just continue in the meantime, just to save time? We'll come back.
No, go ahead, Advocate Mpofu. That's in order.
Thank you. And Mr. In fact, this is relevant so that when it comes up, Mr. Kakana, it's correct that you did the highlightings in that document, correct?
I'm not sure about that.
Okay, well, again, I won't hold that against you, but you sent that document to the public protector, I think on the 20th of June, and you said to her that she must, or rather you brought to her attention parts that were highlighted. If that helps you to remember, I'm simply confirming that those highlightings were made by you, would have been made by you.
I think if you can show me that, I would highly confirm that.
Okay. Okay, I'm hoping that when it comes up, it will come in Technicolor. But If it doesn't, then I'll. All right, there's an email from you which says, hi PP, find attached the draft from Niels. I have highlighted the relevant parts, regards. You don't dispute that. I'm just saying it's from you. That's not the big issue. The big issue is that you highlighted the relevant parts yourself.
Sure, I can't recall that.
It's possible that that's what you did.
Just a pause, Advocate Bauer.
Sorry, Mr. Mpofu, I don't want to interrupt you, but could we please ask that we don't have that email, and we haven't really made a fuss about document production, but it would assist if we were getting documents before you relied on them.
Yeah, well, I don't know how the witness is going to answer questions beforehand. So some documents will arise from questions, as always happens in any cross-examination. I've done my best to give you what I can beforehand.
So okay, but are you able to share that document that she's?
Yes, I have, and I phoned Ms. Bauer and told her that the reason why the document was delayed, we sent it maybe 2 hours after we had promised, was exactly because we were still looking for related documents, but I didn't want, because it was the longest document, I said to her, I'll send it to her anyway.
Okay.
Anyway.
I'm not making a fuss about the document prepared by Niels van der Merwe, but you're referring to an email, and that for record purposes, it would be good that whatever you refer to is put into the way we're storing the documents, and that we would have it. So I'm not objecting to the document you sent earlier this morning into which you referred to, but you're reading from a document that we actually haven't seen, Mr. Mpofu.
Okay. Did you get that, Advocate Mpofu?
Yeah, it's fine. I'll send it to her during the tea time or as we proceed. Mr. Kakana, can we? You can, unless if the purpose of this is to use this document to, maybe it will bring back some of your memory. Look at the cover page.
Yes.
Can you see that?
Yes.
Okay, sorry, I can't see the screen share yet. But okay, that's the heading. I won't read it again. I think I read it out yesterday. That's the heading of the document. Do you remember that?
Not that clearly, but I do remember this document, but not that clearly.
No, that's fine. Then, okay, let's go to page. Okay, the pages are not numbers. Can you go to paragraph 1, operator? Okay, I see okay, no, the underlining has not come through. All right, the 1.1, okay, just hold on. I don't know if you can see, Chairperson.
Yes, Advocate Mpofu.
Yeah, I'm putting on the screen, on my screen, the version of the document that I have, just to show you the underlining.
I see what you have underlined there in yellow.
Yes, no, it's not me, it's Mr. Kakana. That's, okay, Mr. Kakana, does that assist you?
Chair, as I indicated, I don't recall highlighting it.
Okay, fine. Let me read it to you. The part you highlighted, it says, as far back as 2008, the Parliamentary Task Team on Oversight and Accountability in regard to oversight and accountability model noted that the Reserve Bank of 1989, as well as Section 223 and 225 of the Constitution, are not sufficiently aligned to the constitutional requirements for mechanisms on oversight in inter alia Section 42 and 55 of the Constitution, as well as the relevant constitutional provisions that refer directly and indirectly to oversight and accountability, to enable the National Assembly to effectively maintain oversight over the South African Reserve Bank, as well as the relevant responsibilities of the Minister of Finance. That part you can see. You might not see the highlighting, but that is what is in the document, probably on your screen, that side. Agreed?
Yes, I think I followed what you read.
Okay. The next part that you highlighted was 1.2, which says the public protector's experience and observations on the current governance arrangements relating to the Reserve Bank confirm that it is necessary to reflect on the constitutional principles applicable to fully fledged central bank within the economic context of our country and the needs of our democratic society. You see that part?
Yes, I see it.
Okay, the next part which you highlighted is 2.3 further down. And it says the South African Reserve Bank and 7 other central banks, Belgium, Greece, Italy, Japan, Switzerland, Turkey, and the US, have shareholders other than government of their respective countries. South African Reserve Bank lists its shares on the Johannesburg Stock Exchange, and currently the shares are held by more than 650 shareholders composed of companies, institutions, and private citizens. You see that part?
Yes, I do see it.
Then you also highlighted 2.5, which says, one of the disadvantages of central banks established under company law is that factors that should be indicative of sound corporate governance, such as social pressures, the interests of the public, and impact on economic return, and the long-run sustainability of the company have to compete with shareholder value, which links corporate interests primarily to those of the shareholders. You see that?
Yes, I see that.
The next part that you highlighted is a 3.2, and it's the second last. Hold on, can I go? 3.2, yeah, oh, thank God. All right, sorry, I see the highlightings are now reflected because I thought you, can you see that, Mr. Kekana?
Yes, I actually opened a separate document, so I am following you as you read the paragraphs.
Thank you very much. Okay, no, sorry, I was under the impression that the highlightings are not visible to the honorable members, but now I can see that they are, so that helps me a lot here. So the next highlighting is then, moreover, financial stability policy, unlike monetary policy, is subject to very strong pressure from vested interests, especially the financial industry, which has effective means to advance its interests. The next 3.4 I won't read out because this just also talks about other countries. 3.5, at the same time, it is argued that in democracies, all power is delegated power, and the parliament is free to make any decisions it wishes. The independence of the central bank can never be absolute. And then let's jump to 3.6. Monetary policy in the traditional national sense includes balancing parliament and the government on the one hand and the central bank on the other. German Constitutional Court case, most of the management monetary policy on an autonomous basis in the hands of an independent central bank restricts democratic legitimacy and therefore affects the principle of democracy, according to the Constitutional Court, acceptable as it took account of the particular mention that an independent central bank is a better guarantee of the value of the currency. The other one is too long, it's at 4.3.4. In about 1/5 countries, the law provides for government or parliament to give directives to the central bank and set rules around the procedure to be followed. Examples of such mechanisms are to be found in Australia, Canada, New Zealand, and Norway, and so on and so on. The only point I want to make is that this was quite a serious comparative study in economic models pertaining to reserve banks in other jurisdictions. You would agree with that summary, correct?
Yes, as I indicated, it seems as if it was a comparative study.
Yes, no, I know it was a comparative study. I'm asking you something different. That it was a thorough analysis of the models and economic models, particularly in relation to the constitutional regimes of reserve banks in other countries as compared to ours, correct?
I would agree.
Thank you. Now, so this is some of this is not consistent with your theory that all this issue about constitutional amendment simply came from the SSA, is it?
No, I don't understand your question.
Okay, this amount of work which was done thoroughly within the Public Protector's Office itself and is not consistent with your theory that the whole issue of constitutional amendment simply came from the SSA and not from the Public Protector. You would agree with that?
I never said the theory of amending the constitution came from the SSA. I indicated that the SSA gave us a note which contained a draft amendment of the constitution.
Okay, I see. So you never said that the recommendation to change the constitution came from the SSA?
I said the recommendation that was provided to us came from the SSA.
By that you meant just a piece of paper, or did you mean the recommendation itself, the idea?
The piece of paper.
Oh, I see.
The idea from what I know, according to my personal knowledge, always came from the PP.
Good. So, okay. Thank you. That's a major breakthrough. So you accept that the idea was generated by, among other things, by the interactions you had with Mr. Goodson, correct?
I wouldn't know what the motive for the idea would be.
No, I'm not talking about motives, Mr. Kekana. I'm saying, do you know that the idea was, among other things, influenced by your interactions, you and the PP, with Mr. Goodson?
I don't know.
Did Mr. Goodson not talk about this idea in your discussions with him or in reading his book?
Yes, we did talk about that.
Yes. Now, so why is it so difficult to accept the obvious that those discussions were not just for fun, that they played a role in shaping the idea, correct?
From my personal knowledge, the idea came even before we discussed with Mr. Goodson.
Yes, but then what would have been the point? Let's assume it came even before, but it was also influenced, that's what I'm saying, by those discussions. Otherwise, those discussions would have been futile. Why would you have discussions if you were set in your ways and had a closed mind on the idea?
According to my personal knowledge, I wouldn't know about influence, but what I know is that the Public Protector needed Mr. Goodson's assistance in the matter, yes. and he provided us with inputs.
Good, that's good enough. So it can then be said that the idea emanated from the interactions with Mr. Goodson and from the Public Protector.
I don't know where the idea emanated from.
Okay, I thought you just said it came from the PP, but now you don't know. All right, that's fine.
Just pause there, Advocate Mpofu. Mr. Kekana, can you repeat that? Because you did say that originally the idea came from the PP, it came from the Public Protector.
That's correct. It came from the Public Protector, but I don't know what motivated the idea.
That's okay. That's fair. Thank you. Advocate Mpofu?
That's fine, Chairperson. I won't belabor the point here. As long as we know that the idea did not come from the SSA. But in fact, even if it did come from the SSA, we have established that the SSA was the lead department in the contract with CX, correct?
Yes, the SSA signed the contract with CX.
Yes, and if it was any other department, Home Affairs or whatever, then we should sign the agreement, then you would have been interacting with that department, correct?
Yes, to find out what's their version of or their account of the investigation.
Yes, so this idea which is bandied about in the media narrative that there was something strange simply because by coincidence, the department that signed the agreement on behalf of the government of South Africa happened to be intelligence department is unfounded. Would you agree?
Chair, can I get a repeat of the question? I don't understand the question.
I'm saying the idea that simply because the signatory department was the intelligence department, the idea that there was something sinister is actually unfounded because you as the public protector had to follow the contract, so to speak. So if it had been signed by the Department of Arts and Culture, you would have been interacting with that department. But this one was signed by the Department of Intelligence.
I still don't get it. Is your question, counsel? Is your question, counsel, saying that the idea for the mere fact that SSA signed the contract with CX Ltd, it was sinister? Is that what you say?
No, I'm saying the opposite, that it was not sinister. And to portray it as sinister is wrong.
Chair, I wouldn't have a view about that. I don't have knowledge about that.
That's fine. You've seen the contract between CX and the South African government signed by SSA. Have you?
I did see it during the investigation.
Yes. And the essence of that contract was that CX undertook to provide intelligence in the form of evidence to the South African government and advice in relation to various issues, including trying to recover the money that belongs to taxpayers, correct?
Yes, more or less, yeah, correct.
Yeah. Thank you. Now, again, when this was being discussed with SSA, there would have been nothing wrong with them bringing along somebody that they regarded as an economic expert or from their economic division. I'm sorry, I don't know how NIA works, but that is also not sinister that they would have people who might have some knowledge in this area, correct?
I'm not so sure in what context you are asking that.
I'm asking it in the context of explaining the presence in the meeting. You had the principals, let's call them that. That is the minister and Mr. Arthur Fraser, correct, as the senior people in the delegation that came to meet with the public protector. Am I right?
Yes, in the initial meeting or the first meeting we had with the SSA,
Yes.
the minister was there, the DG was there, and Mr. James Ramabulani.
Yes, that's what I'm saying. So, in fact, let's start with Mr. Ramabulani. So, I'm saying then, if the leadership in the form of the minister and the DG were to discuss a matter like this, they would bring somebody with more detailed knowledge, if you know what I mean, such as Mr. Ramabulani of the matter, correct? There's nothing sinister with that.
Chair, my answer to that would be that people who would come generally to a meeting would have knowledge of the aspects that we are investigating. Correct.
Now, I'm putting it to you that Mr. Ramabulana and Mr. Moodley at very different levels or to varying degrees had some input to make on this matter. You would agree with that general statement?
I'm not so sure what input would that be, because I did not receive any input from Mr. Ramabulani, and from Mr. Moodley, we only received the note that I mentioned in the affidavit.
Yes, okay. But from common sense, if the minister and the DG bring, let's call it the people who are at the lower levels of the leadership of that department to a meeting about whatever, then you would expect that those people are there to support the minister and the DG in the particular area that is being discussed. That's why they are brought to such a meeting, just from your knowledge of life in general and meetings.
Yeah, in general, I would suppose so.
Thank you. Right. Now, the evidence from the PP will be that, like you, she might not remember all the details specifically of which meeting or who was wearing what, because it was a long time ago. But that these gentlemen were presented, Mr. Moodley in particular, as some kind of economic expert who had also worked at in the South African Reserve Bank space. You can't dispute that, correct?
I only know that he was introduced to me as an economist.
Yes, I know that. That's where I'm getting at, Mr. Kekana, as to why he might have been introduced to you as an economist. I'm saying, you and I spoke yesterday about what that definition might entail. I'm saying that you cannot dispute either it was said in your presence, or you cannot dispute if it was not said in your presence that Mr. Moodley had worked in the South African Reserve Bank environment.
I don't recall that.
You cannot dispute that he was coming from the economic unit, and don't hold me to that term, but unit, division, or whatever, but from the economic side of NIA.
I was told he was an economist from the SSA.
Yes, and do you know that he also holds an MBA, Master in Business Administration?
I don't know any other personal details about Mr. Moodley.
About him, okay, that's fine. Okay, you know what an MBA is?
I've heard of it, yes.
Yes, okay. And you'd expect somebody who's got a master's in business administration to have some knowledge of economics. I'm not saying that they would be professors of economics, but they would know something about economics and finance and those kinds of things, correct?
Generally, yes.
Yes, thank you. Right. Now, fortunately, we now have agreed that the idea was discussed at the instance of the public protector. And her evidence will be that one of the issues, and I think in fairness to you, you already had said yesterday that you could not comment on this, but I'm just bringing it back for context. One of the issues that she was raising with the leadership of NIA was the possible impact on economic stability of whatever would come out of this particular report. You should know that she had such concerns, at least at a general level. Do you or don't you?
No, I don't recall that.
Okay, fine. That's fine. Fair enough. So her evidence will be, and again, this might not be necessary anymore to lead you on this because you've already considered that it was the idea came from the public protector, assisted by Mr. Goodson, as well as some other internal work which was being done by the likes of Mr. van der Merwe in the public protector's office. But for what it's worth, the public protector then, what she was really seeking from these people was to say, this is my idea. I want to make sure that it is articulated in such a way that it does not create any instability. And it was in that context that they were asked for input. You can't dispute that.
I don't have a view on that.
Yes, but you are the person who was, shall we call it, raiding. Maybe raiding is a strong word. Who was making the inquiries as to where is the input in your emails, correct?
Which input are you referring to?
The input that you were seeking from Mr. Ramabulana, for example, in the emails that Ms. Bauer sent to read to you.
Yes, we were.
Do you remember the emails you sent asking about the whereabouts of the input?
But I didn't hear that properly.
Oh, sorry, Mr. Kekan. Do you recall the emails that you sent to SSA inquiring about the whereabouts of the input that they had promised?
Yes, I do remember making follow-ups with Mr. Ramabulani.
Yes. All I'm saying is that the input that you were asking for had been sought on the basis that I've just summarized on the part of the public protector. You agree?
Which input would that be? Are you referring to the note from the SSA?
No, input is a general thing, Mr. Kekana. It could be a note, it could be a megaphone, I don't know. I'm just saying the input that you or narrative, yeah, to use your word, yeah. You said, this is your email. Thank you very much, Ms. Bauer, or whoever is operating. On the 19th of May, 2017, you wrote a letter to Mr. Ramabulana, correct?
Yes.
And you copied the public protector advocate, Busisiwe Mkhwebane, correct?
That's correct.
And it says, kindly note that this is a reminder about the promised narrative from the department. So that's you can't ask me which input. What narrative were you talking about?
I was talking about the narrative on their role in the whole investigation.
No, the narrative on their role included, that's what I'm saying to you, the narrative on their role, and it also included the request from the public protector that I've just summarized, and I'll repeat it for your convenience, that she wanted an input on making sure that whatever she's going to come up with does not destabilize the country, which you've said you know nothing about, but I'm telling you, I'm putting to you as what she's going to say when she testifies.
No, what I can recall is that the input that we sought from Mr. Ramabulani was exactly the narrative as to what was their role in the whole CX debacle. I don't think, or I know that we were not seeking an economist view from Mr. James Ramabulani.
Okay. I'm not talking about just Mr. Ramabulani, sir. I'm saying I don't know. I've just explained to you what the PP had sought from the SSA, okay? You said you don't know about it, that's fine. But I'm telling you that's what she's going to testify. Now, I'm telling you further that in that area of stability, the issue that I've just raised with you, which I'm not going to explain again. When I say stability, you know what I mean. I mean the issue of ensuring that there's no economic instability in the country. In that area, she had asked them to assist her to give an input so that such stability could be assured. Do you understand that?
I do understand that.
Yes, okay, yeah. Now, and as a result, in the next meeting, this economic expert broadly speaking, as I've explained, someone who worked at the Reserve Bank with an MBA and so on, was brought into the second meeting, correct?
From my understanding, Chair, is that the input requested from the economist was indicated to me on the email dated 17 May 2017, and that's TK3. But on the email that was just on the screen there, we were not requesting from Mr. Ramabulani an economist view. We were just requesting from him as to the history of their role in the whole investigation.
Fine, thank you. That's fine. I accept that different things were being sought from Mr. Ramabulani than those being sought from the economist here. All I'm saying is that the public protector communicated to you that she had requested the economic input, correct?
That's correct. That's TK3.
In TK3, yes. And subsequent to that, the input of Mr. or rather the input that was handed over by Mr. Moodley, because I don't know, it might have been generated by other people or in his department or whatever. But that input was then supplied, correct?
Yes, it was supplied.
Thank you. Yeah. So again, we have a situation where, according to your narrative, I'm just summarizing, there are two things that are sought from SSA. One is what you call the narrative from Mr. Ramabulane, the historical narrative about their role. The second one is the economic input, correct?
No, that's not correct.
So there was no economic input sought from SSA?
There was a request from an input from an economist, yes, but we didn't get an economic input. We got a draft amendment to the Constitution.
Regarding the economic sector, correct?
No, we got a draft amendment of the Constitution.
Yeah, but, okay, thank you, Mr. I'm sorry. I'm saying that draft amendment did not regard the health issues. It regarded the economic sector, the issues about the Reserve Bank, correct?
Yes, it regarded the amendment to the change of mandate of the Reserve Bank.
Yes, thank you. And that's, would you classify that as an economic issue?
I would regard it as a constitutional amendment. I wouldn't be pressed to say that it's an economic issue from where I'm sitting.
From where you are sitting, are you being serious? So an issue about the mandate of the Reserve Bank, monetary policy, and all these things you underlined in this document, according to you, are not economic issues. The issues about just going to, you underlined more financial stability policy, unlike monetary policy, is subject to very strong pressure from vested interests and the financial industry. That's not an economic issue from where you're sitting.
Chair, I don't know where council is reading from.
I'm reading from your underlining in 3.2 of Mr. van der Merwe's document.
.2.
Yeah. You can read anywhere, wherever you want, anything in that document.
Yes, what's the question about this document?
Whether the issues that you've highlighted in that document do not relate to economic policy and economic issues.
As I indicated, I don't recall highlighting the document.
Okay.
And I do I did indicate that I did consider this document as an comparative economic model document or study or research.
All right. No, I
Okay,
think
no,
that's fine.
thank you for that. I think we have established now that point. Thank you. Proceed, Advocate Mpofu.
Thank you, Chair. No, I think that's fine. I won't waste more time on that because I think it's very clear and the document speaks for itself. So it's no use trying to get Mr. Kekana to agree that this so-called amendment was dealing with economic issues. I think I'll just argue that at the end. Okay. So you therefore cannot dispute that Mr. Goodson's input was also coming from the point of view of an economic expert or an expert on central banking, at least, correct?
I don't have a view on that, Chair.
Even though you spoke to him and read his book?
Yes, I spoke to him and read his book, and I still don't understand the intricacies of economic principles. So I don't have a view on that, Chair.
No, it's not about you, Mr. Kekan. Do you think that Mr. Goodson understands the intricacies of those issues? That's the more important.
He spoke very well. He sounded like he understood what he was talking about.
Yes, and in his book, did you understand what he was saying in his book?
Oh, I had trouble understanding because even though the book painted some nice ideas about state banks, which I found fascinating because it was the first time I was reading about state banks, but I didn't know how feasible or how practicable they are.
No, that's granted. That's not what I'm asking you. I'm more asking you about whether you would regard, it's more about his expertise than your approval thereof. I'm saying that you would agree that he was speaking with authority as an expert in his field. Whether you agreed with his conclusions or solutions is another matter, but he knew what he was talking about. I think that's what you were saying. You would agree with that?
Yes, he spoke as if he knew what he was talking about.
Yes, and his book was also very well researched, correct?
I don't understand well researched.
Okay, I mean, I'll give you an example. There's one chapter where he has something like 57 references from various other books, and that's just in one chapter. And
yes, I think
a well-researched book means that when the bibliography is quite rich.
Yes, I think I remember that.
Yes, and therefore I'm simply wanting to say, Mr. Kekana, that you interacted with the gentleman, you spoke to him, you say you were impressed, you might not have agreed, but he sounded like somebody who knew his subject. I'm simply saying, therefore, you would not fault anyone who regards him as an expert in his field, correct?
As I indicated, I wouldn't be sure because I didn't understand most of the principles that he was talking to us about. So I really wouldn't be sure.
All right. Anyway, that's fine, Mr. Kekana. I think that's good enough. All right. Now let's you would also agree that Mr. van der Merwe's research also was sourced from other economic experts or other books on economics. I mean, he didn't just make up all these things that are also quite complex that you highlighted, correct?
Yes, I did see in his document that he made references to quite a number of documents or books or articles.
Yeah.
Just pause there, Advocate Mpofu. I now recognize Honorable Lottridge. You have your hand up.
Thank you very much, Chairperson, and my apologies to interrupt Advocate Mpofu. I just want to make sure the document that we have of Niels van der Merwe on central banks, the one that is uploaded for us only goes to page 16 and 6.4.4. The rest is empty. Is there the rest of the document? Because I would actually also like to have sight of that. Thank you.
Yes, thank you, Honorable Lottridge.
Just hold. That's in order, Honorable Lottridge. Advocate Mpofu, can you assist there?
Thank you, Honorable Chair. Yes, Honorable Lottridge, it looks like that's the end of it. And that is vindicated by the email which we will be sending to you from Mr. Kekana, because it simply says, hi PP, find attached the draft notes from Niels, that will be Mr. van der Merwe. And then it says, I have highlighted the relevant parts. So he himself, Mr. Kekana, refers to it as a draft. So it looks like this was what one might call work in progress. As Mr. Kekana says that he was sent something by Mr. van der Merwe both before and after the report. So this might not be the final version, but it's the only one that we have. Thank you.
Okay. Just before you proceed, Honorable Heron.
Sorry, I'm going to just take the opportunity, Chair. I just want clarity. I don't know if I've heard it and missed it, or it's not in the documents, but this book, the Goodson book, is it one book? And do we have a name for it, please?
The title of the book.
Yes, you don't have it, but its title is Inside the South African Reserve Bank, Its Origins and Secrets Exposed by Stephen
Goodson.
By Stephen Mitford, M-I-T-F-O-R-D Goodson. And it's published by 2014 Black House Publishing Limited and in the United Kingdom.
Okay. Please proceed, Advocate Mpofu. You may proceed.
Thank you, Chairperson. Right. Okay. I think we are done with the economic experts and no, it's fine. I'll leave that for argument. Mr. Kekana, it is your evidence that in TK2, was the document, your draft report, where the public protector made some proposals, correct?
Yes.
And I'm just hoping that it can be put up. Those are not the same pages. Sorry. Okay, I've been given page 1418, but I suspect that's not the bundle number. But can you go there?
It's bundle B and it starts the affidavit on 2577. And if you want to go to TK2, Advocate Mpofu, then it will be, so hold on a sec. It starts on page 658.
658, thank you very much. Okay. Can you please go there, operator?
The one coming on the screen might have different numbering because it was originally included as part of bundle A, and we then shifted
Yes.
to bundle D. So, but it will be there.
Okay, but both references will work.
It's correct.
Okay, thank you. All right. Oh, sorry, I can't see it on my side. Is it up on your side, Honorable
Not
Chair?
yet, not yet. We are waiting like you as well. So
Okay.
just fix your stuff in the meantime. Hopefully it won't take long.
No, it's fine. It's fine. No, I'm on it because I'm using a hard copy.
And maybe you can start and then
Yes,
as
let me
it comes
start.
up,
Yeah,
so that
Mr. Yes,
will save your time.
just to save time. Yeah, Mr. Kakana, my understanding was that the public protector's inputs were the ones in bold, or rather, not in bold, in capital letters. Correct.
Yes, correct, except for the headings.
Yeah. Well, I don't understand that. So when let's go. Have you got it in front of you, Mr. Kakan?
Yes.
Okay, where I think you were taken to the place for some that says goods and books. And paper from Economist. So what did you understand her to be conveying there when she says goods and books?
Where are you?
It's 2674.
I don't have that bundle.
Okay, fine. Let's then wait
is
until
it paragraph 4.3.7.29?
Yes, at the bottom of that.
Okay. My understanding is that we had to take something from Goodson's books or some form of input from Goodson's books.
Okay. So, and then where it says paper from Economist, what did you understand that to be talking about?
There was some talk that we would get an opinion from an economist.
But at this stage, you already had the input from Mr. Moodley, correct?
I'm not so sure. Maybe just confirm the dates.
Okay. It's if you go back to TK2, it's the 04/05/2017.
No, we received the note from Mr. Moodley on 6 June 2017.
Okay, 2 days later. So the paper from the Economist might have been referring.
No, not 2 days later.
Yes. No. I'm saying it. If it was referring to.
Sorry. It's a month later. Go ahead.
Yes. I'm saying to you, if it was referring to that input, it was projecting something still to be received. In other words, it had not yet been received, correct?
Yes, at that time, we hadn't received the opinion from the economist.
Yes, and then it says the Sars response. You also, had you received that by then?
I don't recall. I think we might have written to SARS relating to the tax implication of the lifeboat.
Yes.
Maybe I think, I'm not so sure. I think we did get a response from them. I'm not so sure.
No, fair enough, Mr. Kakan. It's a long time ago. I'm just saying that might also have been referring to something you were still expecting if you had not received it, correct?
I'm not so sure at the time if I had it or I haven't had it at
You
the
were
time.
expecting it, yeah.
I'm
Okay,
not
fine.
so sure.
Yeah, and then there's something about submission by BLF. Was that, I mean, BFLF? Do you know if that had already been received or not?
At this juncture, I'm also not sure. I'm also not sure. Yeah.
All right. All right. And then she at the, okay, I'm sorry, Chair. 267475. If you go to 2678, that's just a few pages down the line. Go to 5.2. 5.2.2.
Yes.
Yes. Then she put there, okay. Okay, well then, meeting with SSA. What was she referring to there?
The submission that we're supposed to get from the SSA relating to the narrative.
Yes. And had you received it by then?
No, we never received it.
I see. So again, this was something expected in the future.
Yes, we still expected that at this juncture.
Yes. All right. And what else? Then again, on the next page, she then puts the Sars response and documents viewed, SARB response, goods and books, economic view. You've already explained what those are, correct?
Yes, I have.
Then she puts constitutions, SARB Act, Banks Act. Then she put fees must fall, triple challenges, national treasury, SARB, and health, goods in, economist, constitution, freedom charter, bill of rights. You understood, okay, we'll come to the freedom charter and bill of rights, but you understood what she was asking you to highlight in the report, correct?
Yes, in general, I understood, but some of the issues there, I was confused about them. I didn't understand them.
No, I know, particularly the freedom charter. But from this, then it's clear that she wanted you to deal with the meeting with the SSA, correct?
Yes, she still expected, or we expected, the submission from the SSA.
Oh, and yes, no, I know that, but I'm saying one of the things she wanted you to deal with in the report was the meeting with the SSA.
Yes, and that would be the narrative we would receive from the SSA.
Right. Okay. Okay, well, I don't know if we have time, but I might help you. Do you know the connection between the Constitution and the Freedom Charter? Do you know the Freedom Charter?
I think I've seen it some time ago, years ago, if I'm not mistaken. Yeah, but I'm not familiar with the document.
Okay. All right. That's fine. I think let's not go there. But you know that it's connected to the Constitution, or at least there are some people who say that the Constitution owes some of its existence to the Freedom Charter.
No, I don't know that.
You've never heard that view? Okay.
No.
All right. No, it's fine. We'll have a chat about it some other time, you and I. But just for your information, there's an economic clause there that deals with banks and monopoly industries and so on. But it's fine. As I say, one day I'll take you to tea and we can have a discussion.
Yeah, I think so too, Advocate.
Yeah.
Arrange that.
I will. I think it's going to have to be quite a long session. Yeah. No, that's fine. The other issues about fees must fall and health, issues and so on. You also, I suspect you didn't understand what that meant, correct?
Sorry, which issues?
Fees must fall, health issues, triple challenges. I think that's probably just Greek.
I didn't understand the fees must falls and the triple challenges, how they were relevant to the investigation. But in regards to health there, I think it was just a misspelling. I think she meant to say Heath.
Heath, oh, okay.
Yes.
Okay. Yeah,
yes.
no, that's probably true. Okay, the fees must, okay. You understand that if there's more than R1 billion of money that belongs to South Africans that lying somewhere or has been robbed from them, that could pay for free education, for example. I'm sure you, at that level you can understand it.
Actually, I don't want to venture into that. I don't have an opinion on that.
Okay, but do you know that if there's free education, somebody has to pay for it, and that somebody would be the state? At least you must know that. There's nothing free in life.
I do know that the state does cater for our education financially, but I cannot get into discourse as to whether if there's money owed where it would be paid where. I'm afraid I don't have a view on that.
No, that's not what I'm asking you. I'm asking you, this is 2017. Do you know that one of the hot issues at that time was hashtag fees must fall, which required that the government should come up with funding for free education or not?
Yes, I was aware of that.
And do you have you don't have a view on certain things, but do you have a view on whether it would be a good thing to recover 1.25 billion rand that belongs to the citizens of South Africa?
Yes, it would have been a nice thing.
Good. Okay. Right. Then let's go to the issue of Rule 53. You were in charge of compiling the Rule 53 record, correct?
Yes, initially I was charged with making a copy of the file and providing to Mr. Namasisi. And at the later stage, I was asked by the appointed attorneys to come and assist with identification of documents.
Yes. You'd accept as a, I know, well, you are a legal person, as a general statement that the compilation of Rule 53 records is done by, at that level that you are discussing, the attorneys and the legal department of the public protector. It's not done by her personally. That should be obvious, correct?
Yes, it was done at the stage by the attorneys involved.
Yes, and you said you compiled and you put all the documents to be given to that process of compiling the Rule 53 record, correct?
Yes, I provided all that I have.
And you did not ask the public protector's permission before you provided those documents to the attorneys?
No, before I did that, there was just no discussion on that. I was just told that I must provide a copy of the file to the attorneys, well, through Mr. Namasisi. So that's what we did.
Yes, that's what I mean. Those documents were not vetted or approved or disapproved by the public protector, correct?
I don't remember that.
You don't remember what?
I don't remember whether they were vetted or anything. As I indicated, I made a copy and provided it to our legal services.
Yes, Mr. Kekane, please. I'm asking you a simple question. When you did that compilation, I'm asking you, please assist the committee. You had a free hand. Nobody said, don't put this, take this out. You had a free hand. You compiled the documents, you gave them to the attorneys. What's so difficult about that?
What's the question there, Council?
Do you agree with what I've just said, that you had a free hand in compiling the documents and nobody said you must not put this one or don't put that one?
Yes, as I indicated, I made the copy of all that I had in the files and provided to the senior manager.
Yes, everything that you consider to be relevant to the case, correct?
No, everything that I had.
Or even more. So you even put things that
I also put my notes there. I put everything. I made a copy of everything.
Yes, that's good. No, that's very good. And but you said that your email was inexplicably omitted. Who omitted it? It must be you then.
Sorry, which email?
You said it was the email, I think, that we just discussed now. The one that says
TK2.
No, not TK2. It's the one, you remember where you just referred to it now, where the
draft report.
No, not that one. The one where the PP said an input from she had asked for an input from the Economist. Is that one?
That's TK. Oh, TK3.
It's probably TK3. Yeah. Hold on. Yes, you are quite correct, Mr. Kakan. TK3. You were asked about this. It's a 2681 for the record. And you said this email, this is your evidence in chief. You said this email was inexplicably omitted from the Rule 53. That's how it has been reported in the media. So I'm saying that you were the person who compiled the record. So if anything was inexplicably omitted, then it was omitted by you, correct?
That's not correct.
Then who omitted it?
I wouldn't know who omitted it.
Mr. Kekan, I don't think you're assisting this process. But that's just what I'll argue at the end. But you accept that the responsibility for the compilation of this document lies on your door, correct?
Chair, as I indicated, I was instructed to make a copy of the file, and I made a copy of all that I had and provided it to the senior manager.
Yes, I accept that. I'm not saying you did it deliberately. I'm saying in doing so, you might have added things that maybe did not belong to this file by mistake. I'm granting you that, or omitted something. But that's not the point. The point is that the responsibility lies at your door, because you are the person who with a free hand, compiled this Rule 53 record, correct?
As I indicated, I gave a copy of everything that I had.
Yeah, thank you.
Thank you. All right. Then you spoke about okay, let me put it this way. You say you don't know who omitted that document, but it must have been between you or the attorneys or Mr. Namasisi. Those were the three persons. There might have been article clerks or whatever. I'm not going that far. But those were the three persons who were responsible for this exercise, correct?
Chair, I wouldn't know who might have omitted that.
Yes, but Chair, I'm sorry, Mr. Kakana, yes.
As Chair, as I've pointed out during my testimony earlier, I did indicate that the PP did instruct me that we were not to disclose our drafts reports. This was one of the draft reports that we did. So I'm not so sure where that discussion ended with the attorneys. So I'm really not so sure as to who might have omitted it.
No, that much you've made clear, but in your evidence, you were insinuating that it was the public protector, and I think you are trying to do that again now. So let's go into that. You cannot ascribe the omission of TK3 to the public protector, right?
Chair, as I indicated, I don't know who omitted that document.
Yes. Yeah, I know that you've answered that. I'm asking you a direct question, Mr. Kekana. Please learn to answer the question. You cannot ascribe the omission of that TK3 to the public protector, correct?
Chair, it could have been her, it could have been the attorneys, I don't know, Chair.
Yeah, it could have been me, it could have been John Smith, it could have been my junior. You yourself cannot ascribe, it could be anybody or any of the 60 million South Africans, correct?
Chair, I've answered that question.
No, he did, Advocate Mpofu. Please.
He did not, Chairperson, he did not, you know.
No, he is indicating that it could have been the public protector, it could have been the attorney, could have been anybody in that office. I think the point is canvassed. Thank you.
Anyway, that's fine. Mr. Kekana, you have been found guilty of dishonesty, correct?
That's incorrect.
All right. You have not been dismissed because of dishonesty?
No.
Did you distribute documents that were sent to you by mistake?
Chair, as I indicated before, I will not have a view on the issues which are pending at the Labour Court.
No, Mr. Kekana. You have a view about issues that are pending before the criminal court in respect of the public protector. So you think you are the only person who has rights in South Africa?
Chair, I've indicated my view.
Well, Chair, can you please direct the witness to answer the question, because I told you about the double jeopardy and you said we must go ahead. It can't apply only to certain people. Please, Chairperson.
Just repeat your question, and I would like him to repeat his response in the manner he deems he wants to do it.
All right. Okay. I'll repeat the question. Let me just put it. If you bear with me, Chairperson, just for. Yes. Mr. Kekana, your disciplinary hearing was chaired by Mr. Fourie, correct?
Yes, that's correct.
Yeah. Okay. Now the part I'm just going to read some of what he says. It says, in my view, the employee disregarded and breached the relationship of trust between him and the employer by disclosing confidential information that was sent to him in error, well knowing that it was not meant for him. His relationship as a shop steward with the Public Service Association, and the advantage that it could gain from confidential information it came to his attention by mistake was at the time of more importance to him than his duties and responsibilities as an employee. And then at 14, he says, however, this was denied, rather, the employee showed no remorse for disclosing confidential information during the proceedings. He initially suggested to Ms. Mafa that she deliberately disclose information to him relating to travel arrangements of the former chief executive officer after she had discussed it with him. However, this was denied in his evidence. Instead, he agreed that Ms. Mafa provided the information to him by mistake. In my view, this indicates dishonesty on his part and a late attempt to shift the blame. You remember that part?
Not that clear.
You did receive the outcome of your disciplinary hearing, correct?
Yes, I did.
And that's what I was reading from. Have you forgotten now, or is that a convenient way of forgetting it?
Maybe when you started, I disagreed with you, and I still disagree with you that I was charged with dishonesty. I think maybe the way you started confused me because I was charged with unauthorized disclosure of confidential information. I was never charged with dishonesty.
No, that's it's probably the way I phrased the question. I'm sorry, Mr. Kekana. The question should have been: were you found guilty of dishonesty? Were you found to be a dishonest person?
Counsel, I think you're going there again. You're saying I was found guilty of being dishonest. I just said I was charged with unauthorized disclosure.
Okay. No, thank you. No, fair enough. Was a finding of dishonesty made against you by Mr. Fourie?
He did mention that, but I was not charged with that.
No, I didn't say. Mr. Kekana, please don't waste our time now. I've changed the question for your convenience. Was a finding of dishonesty made against you by the chairperson of the disciplinary hearing?
No, Chair. I was found guilty of unauthorized disclosure of confidential information.
I'm asking you the last time. Was a finding of dishonesty made against you by Mr. Fourie, the chairperson of the disciplinary hearing?
Chair, I've made or submitted an answer to that.
So you're refusing to answer the question?
He has answered that question in the way.
No, Chairperson. No, Chairperson.
He just indicated what he was found guilty of.
I'm not interested in what he was found guilty of, okay? So he might say it if he wants to tell people who are interested in it. I'm asking a different question. Was a finding of dishonesty made against you, yes or no? Not what you were found guilty of.
Chair, I've made a view on that question.
Okay, thank you. I've noted that. Please proceed, Advocate Mpofu.
Sorry, Advocate.
Just a pause, Advocate Bauer and Honorable Ngola.
Advocate Mpofu, just as a information, which paragraph were you referring to? In the ruling?
I think it's 13 and 14. Let me just make sure. 13 and 14, yeah. I started by reading 13. The finding of dishonesty is on paragraph 14, 1-4.
Okay, just a pause, Honorable Ngola and then Honorable Sukas.
Well, thank you, Chair. No, I just wanted to request that can the findings of the disciplinary hearing against the witness on stand be shared with us as well, so that we know where Advocate Mpofu is referring from. Thank you.
That's in order. Honorable Sukas.
I just want to know, Chair, just as a point of clarity in terms of the application of the rules, in the witness being uncomfortable or not answering a question, they reserve the same rights, I take it, in terms of being able to respond at a time convenient to them, whether it be in 7 days or not. I'm asking.
That's what I'm on at. I'm carefully watching that space. Thank you, Honorable Sukas. Is that being made available before Advocate Mbofu proceeds? Do we have that?
Well, Chairperson, yeah, I'm not taking your job, but there's no such thing as a witness answering in 7 days. The witness must answer now. That is not on the cards, and it's not covered by the directive. But be that as it may, yeah. And so the witness, I'm just saying, yeah, if the witness feels the heat and the over question, he can say, I'll answer it in 7 days.
No, the witness did not speak about 7 days. The witness has been answering questions since yesterday and today. We might not like the answers he's giving. He is giving answers.
Okay, no, then maybe Chair, you missed what Honorable Sukas was saying. She was talking about 7 days of. That's fine. That's in any event that's. I was just assisting that the 7 days rule doesn't apply to witnesses.
That's fine. Let's proceed.
Okay.
Advocate Bauer, just switch off your mic. Thank you. Go ahead, Advocate Mbofu.
Yeah. Yes. Please answer the question, sir. Was a finding of dishonesty made against you by Mr. Fourie?
Chair, I've already given an answer to that.
So I take it you are refusing to answer the question.
Chair, I've given my view to that, Chair.
Yeah, I think let's proceed, Advocate Mbofu.
No, Chair, I'm sorry.
He had given an answer more than once on your question.
Yeah, but Chair, so you can stand up and recite the letters of the alphabet, and you say he has given an answer. He's not answered my question. You can't just say he's given an answer if he stands up and saying hallelujah.
As I indicated, you might not like the response and the answer. He has given his response and an answer to the question you asked several times.
Yes, Chairperson, I'm explaining to you with the greatest respect that I'm expecting him to answer my question. You can't just say because he has moved his lips and something came out of his mouth that he has answered my question.
No,
he has not answered my question.
No, Advocate Mbofu, I don't think we are going to labor the point here. The question has been answered, and he has indicated where he stands on that question. Honorable Melder.
I think anybody listening.
Just pause, Advocate Mbofu. Honorable Melder.
With all due respect, that is the approach of Advocate Mbofu. He could also perhaps supply the witnesses with the answers that he expects.
I didn't get that. It seems that Advocate Mbofu is being cut out. Honorable Heron?
No, Chair, I'm sorry, with respect, I don't think the response from Honorable Mulder is correct. I mean, the witness has been asked to confirm that in a disciplinary finding, there is a paragraph that says that the witness was found dishonest. I don't understand why why it's not correct to put to him and why he can't answer yes or no that's in the finding.
That's fine. Advocate Mbofu, you seem to have cut out. Are you there? You're muted.
Yes, no, I was removed. So I think that I just saw Honorable Heron, literally the last 2 words. So if you could just maybe summarize, Chair, what he was saying.
No, he was requesting that the witness responds to the question that you've posed again.
Thank you. Hallelujah.
It's fine. Mr. Kekane?
Chair, maybe let me see the document that Council is referring to, and I'll
You don't have that document?
Or no, I don't have it with me currently.
Okay, so are the members.
Sorry, Chairperson. Yes, Ms. Bauer will. I'll move to something else then, Chairperson, for now, just to save time until it has been displayed. Oh, there you are. It's paragraph 14.
Is that the last sentence?
That's correct, Chairperson.
In my view, this okay. You want to respond to that, Mr. Kekana?
Yes, Chair. I would respond that that's what Mr. or Advocate Stoffel-Fourie indicated in his findings or in his report.
Thank you.
Okay.
Thank you. Thank you, Chairperson, and thank you, Honorable Heron. Now,
at that point, Advocate Mpofu will pause there for tea break for 15 minutes.
thank you, Chairperson.
We'll be back at quarter to Mr. Kekane, quarter to 12.
Noted,
Recording stopped.
Thank you.
Before we adjourned for tea break, Advocate Bauer flighted a document there by the screen, but only shown us paragraph 14 of a document that we do not have. So I wanted to check if are these that which Advocate Bauer flighted on the screen, the findings of a disciplinary hearing against the witness on stand. Thank you very much, Chair.
Thank you. Just before I go to you, Advocate Mpofu, Advocate Bauer.
So there was a disciplinary hearing of Mr. Kekana. The disciplinary officer was Mr. Stoffel Fourie, who was a senior executive manager. There are two documents. One document says decision, and then he finds him, and the decision deals with conclusions. He finds him guilty on charge and he discusses 3 charges in that document that he finds him guilty on. And then there's a second document, which is called Ruling on Sanction, which is the document of the 27th of August 2020. And it's that document that contains it. And it's the reasoning of the disciplinary officer in respect of the ruling on sanction. So there are 2 documents. The first one is the basis upon which he finds him guilty, and the second one is called the ruling on sanction. And we'll make them available to the members.
I think that will be important. Can we urgently make those 2 documents accessible and available to members so that they start applying their minds? And it might be important if those would be made available before 2:00 when I start with the members. Thank you. Advocate Mpofu, proceed.
Thank you, Chairperson. Yes.
Just a pause. I see a hand of Mr. Zungula.
Thank you, Chair. Chair, there's one thing I would like to raise. In the previous, before we went to tea, there was this issue where the witness that is under oath was somewhat being evasive and refusing to answer a question. Very, very simple and straightforward question. Now, Honorable Muda spoke and said, Advocate Mpofu must, he must say the kind of answers that he wants. Now, I found that, Chair, to be first misleading because the witness was not answering a direct question. So I would like you, Chair, to also protect Advocate Mpofu because it can't be that a member of the committee is somewhat suggesting that Advocate Mpofu is not happy with the answer, whereas the witness under oath is refusing to answer a direct question. Thank you, Chair.
Thank you, Mr. Zungula. Your point is noted, definitely. Advocate Mpofu.
Thank you, Chairperson. Chair, yes, before I ask my next question, I think I must register this. Unfortunately, thank you, Honorable Zungula. I didn't even know what Honorable Zungula was talking about because it must have been the time when I was switched off. And I only caught, as I said, the tail end of the Honorable Heron's input. So I didn't realize that I had just been insulted once again. I thought today will be the one day that I'm not going to be insulted. Chairperson, I'm appealing to you for protection once again. You have not protected me or Advocate Mkhwebane since day one. Literally every day, I have numerous examples of being exposed, insulted, and not once have you come to my protection, not once. And therefore, it's very important.
Please go ahead, but your recollection of that is inaccurate, and I've done that a number of times. That recollection is inaccurate.
Oh, that's fine, Chair. But that's my view of it, and the record will speak for itself. If also you're not protecting me from the members. I don't know on what basis Honorable Mulder could say that I don't like an answer. You know, cross-examination, maybe we'll explain it at some stage. Maybe we'll bring someone to explain what is the purpose of cross-examination. Cross-examination has been described as the best engine ever invented to extract the truth by Wigmore, who is an authority on such issues. But it's also the best engine to expose lies as well. And that's what we're busy doing. And one of the ways in which people don't give evidence properly under oath is to evade questions, or to not to answer simple questions, or to give all sorts of roundabout answers. If Honorable Mulder does not know that, then I will, or anybody else, I will bring an expert to explain how these the implications of these things on any process such as this one. But what I will not stand for, Chairperson, is to be abused by anybody. I've made that very clear. I will not be abused or bullied or intimidated or derailed. But it's fine. This is not about me. It's about Advocate Mkhwebane. You can abuse me as much as you like. I will never be bullied. Bigger people have tried to bully me for the past 40 years or so. And
thank you, Advocate Mpofu, I think.
So it will never work with me. So, and I'm not worried about that. I'm not worried about the process. Me, you can do whatever. I mean, you know.
That's fine. Can we now proceed to your cross-examination?
No, I'm not going to. No, I'm going to address you now. And then, so you don't protect me. The members are abusing me. And the other thing I want to raise is about the evidence leaders as well. I also have to place on record, because people are following this process, and we've all said that it's a new process, that we have not, it's uncharted waters and so on. The evidence leaders are not prosecutors. So their duty is to expose whatever, whether it's in favor of Advocate Mkhwebane or against her. Their role is now becoming to look like prosecutors. Even prosecutors, for that matter, have a duty to expose evidence that is against them. So to sit here with a witness who has been found guilty of dishonesty, and it's not in the so-called summary and the build-up, we're told about this case and that case and that case. At that point, we should have also been told that this witness has been found guilty of dishonesty. What if we didn't have it? Because the idea is to assist the members. We might not have had this document, and the evidence leaders have got it, and it's not brought to the attention of the nation, because this doesn't even belong to parliamentarians.
Advocate Mpofu. Thank you, Advocate Mpofu. Suppose I'd want you to proceed to your cross-examination, but before I allow you to do that, I've made a point here, and I want you to refrain from that. Your recollection of you not being protected in a public protector from the chair is inaccurate, and I want to make that point, and I hope it's not going to be repeated. But secondly, when issues are brought to the attention of the chair, at no point that matters are not being attended to. So I'd want you to proceed to, and at some point, whether later today, I will address you on this point of double jeopardy as a chair, and Indy, because you've just raised something similar to that about issues of prosecution and so on. I will attend to that and address the hearing on that. I now recognize, before you proceed, the hand of Honorable Nodat and Honorable Lucy.
No, thank you so much, Chair. Chair, you know, I mean, I think we've been sitting on these hearing for the past couple of days now, and I think it's very important, Chair, to understand that there's a very clear distinction on what our role and responsibility is as a committee, and what we need to consider as a committee from all that is representing here in this committee. But secondly, Chair, also as members of this committee, we cannot be sitting here and be referred to as dealt with bigger people and so on, and whatever the case may be. We need to respect each other here. There's a process that we need to run, and it's important for everybody to be protected in this process. And there's been jabs and comments that have been made, whether to witnesses, whether to the committee, whether to you as a chairperson, and that is unacceptable. Neither are we going to sit here and be insulted or bullied, whatever the references may be, because we've got a responsibility to do justice to this process. And this process needs to be fair on all that participate in it, including Advocate Bof and Advocate Mkobane and her team. So I think, Chair, let's just hold the decorum of the House and not degenerate and throw comments and insults, because then we lose the whole purpose of this. I really plead with you, Chair, to chair this meeting and facilitate it in all ends. There's nobody who's special more than somebody else here. We all have a responsibility to play, and let's do that. Thank you so much, Chair.
Thank you, Honorable Nodada. That's in order. Honorable Luzipo.
Oh, thank you, Chair. I won't take your time. Can we agree that there is a process we agreed to? That let's go through that process. Where there is a concern about proceedings, can we all go to the back room as agreed? Or if you were a judge, I would say to your chambers and deal with the issue. For now, let's continue with what we are doing. All those issues must be dealt with outside this meeting. Thank you very much.
Thank you, Honorable Luzipo. It's just that some of these issues don't need a back room. They've got to be attended to on the spot in the meeting, because they are part of what the directives are asking us to do. So the point is taken, but it's because it's not just confusion between the evidence leader and the legal team of the public protector. Some of the issues go straight to this constitutional process that we're driving as the National Assembly. Thank you for that. Advocate Mpofu. Sorry, I see a hand of Advocate Bauer before we proceed.
I do feel that I need to respond to the allegations made against the evidence leaders.
Yeah.
Having the allegation made that we have failed to disclose a guilty finding on the question of dishonesty in respect of this witness. I do not find in the guilty findings on the charges which Mr. Kekana faced to have included in charge 1, 2, and 3 a finding that says, I accordingly find him guilty of dishonesty. I, during direct examination, expressly stated that he faced disciplinary proceedings, he was found guilty, he was dismissed, the matter went to the CCMA, it was dismissed, and his proceedings are pending before the Labour Court. It has not reached finality.
Thank you, Advocate Bauer, for placing that on record. Advocate Mpofu, can we resume?
Yes, Mr. Kekana.
Yes, I'm here.
Yeah. As an attorney of South Africa, do you think it's important that a finding of dishonesty has been made against you in any context?
I don't understand the question. Can you repeat the question?
As an attorney and knowing the rules and ethics, do you think it's important that such a finding of dishonesty has been made in the context of your disciplinary hearing? In other words, if you wanted to be, let's say, admitted as an advocate, would you have to disclose this dishonesty issue?
I don't understand, because I wasn't charged with dishonesty. I was charged with unauthorized disclosure of confidential information. So I was not found in any way guilty of being dishonest.
No, I'm not saying, no, that's Advocate Bauer's words. It's not mine. You remember I changed the question about guilty as in the charges. I accept that you are not charged for dishonesty. I accept that you were not, therefore, because it was not one of the charges, it was not one of the verdicts. I'm saying that in the finding of what you did, of your conduct, an element of dishonesty was found. Do you think that is important for somebody who's an officer of the court?
Is that the complete question? Is that what? Counsel?
Yeah. Do you think that is important and a disclosable fact for someone who's an officer of the court? Question mark. Yeah, that's the end.
I'm not so sure, Counsel. I do know that one has to report certain conducts, but I wouldn't be sure about this, the one that you're asking, Counsel.
Okay, no, that's fine. Yeah, I think so. Do you, have you lied under oath before?
No.
All right. Did you, under oath, supply confirmatory affidavits for the public protector in the CX matter?
Yes.
And you were confirming, are you still standing by the fact that you were supporting what she was saying as your version of events?
The confirmatory that I remember signing was the one dealing with my handwritten note and the Rule 53. Unless if maybe you can point me to some other document, but that's the one I remember off the cuff.
Did you ever, you know that when you lie by commission or by omission. Did you ever, until you were charged and for distributing information which did not belong to you, did you ever express this, your so-called discomfort to any authority?
Discomfort in regards to what?
All the things you found odd and which you did not agree with, allegedly.
Well, in my affidavit, I do point out that I did report this to an attorney and an advocate.
You reported what? No, that's not what you reported to the attorney and advocate was another lie, which was that the constitutional amendment came from the SSA. We've now established that that was not correct. And you know what I'm talking about, authorities. I'm not talking about you gossiping about the public protector with lawyers. I'm talking about making a report. Did you ever make such a report?
Chair, I did not gossip with any attorney. I informed them of what happened during the investigation. Apart from reporting it to them, then I made the protected disclosure.
Yes, but you say, this is what you say you told them. No, the protected disclosure, forget about that. That was 2 years after the event. You are not a whistleblower. We established that yesterday. You are the exact opposite of a whistleblower. A whistleblower is somebody who must be protected from the company retaliating to them for making a report. Do you accept that?
Chair, I cannot agree with that, and I cannot disagree with that. I don't have a view on that proposition.
All right, let me tell you for free. A person who is in respect of whom something is done, and then they retaliate to the company, is the exact opposite. It's when the company retaliates against you that you become a whistleblower. When you, as you are doing now, are retaliating for the company for getting rid of you for your dishonesty, then that is not whistleblowing. It's the exact opposite. You are not a whistleblower. You are a whistle inhaler, whatever the opposite of whistleblower is. Okay, so that's...
I don't think you need to go to that level.
Yeah. No, that's fine. Thank you, Chairperson. That's fine. All right. No, I was saying, Mr. Kekana, this is what you said in your evidence in chief. I told them that when you are talking to the lawyers, I told them that the recommendation to change the constitution came from the SSA. That's what you told the lawyers. That's what you are talking about now, correct?
Yes, yes, meaning the note that was handed over to us.
No, but that's a lie, Mr. Kekana. A recommendation, the impression you were giving is that the recommendation to change the constitution came from the SSA, but you knew that the recommendation came from the public protector and Mr. Goodson in your presence, apart from the issue of the piece of paper.
Chair, I would like to repeat my answer that the note that we received, TK4, it does indicate at the top recommendations. And it was a note that we received in regards to the amendment of the Constitution.
Okay, fine. I don't want to go back into that. We've established that that was something that the public protector told you she had asked for input from an economist, but now you are obfuscating it again. That's fine. Anyway, I'm sorry, Chairperson. Right. Okay, Chair, if you allow, Chair, please, there's just something that I noticed during the break. I just want to round off the point that I was making about TK3, the attachment to TK3. Mr. Kakana, can you go to 2674, no, 2678, Chairperson, sorry. After the fees must fall things. 2678 to 680.
So the paragraph?
Okay, let me use the nearest, it's around paragraph 6, Mr. Kakam.
Yes, I'm at paragraph 6.
Right. I just wanted to highlight once again some of the issues that were inserted by the public protector. In the middle of that page, it says, she says, substantiated because the monies were never recovered and use written submission of SSA. You remember that?
Yes, I see that.
Yeah, what was she conveying to you when she was saying you must use the written submission of SSA?
I cannot recall that. Sure, I really can't recall that.
Okay,
but
that's
I
fine.
think what she meant was that we were to use the written submission that we would get from Mr. James Ramabula.
Yes, okay, but what it certainly does not mean is that you must conceal the interaction with SSA. It means it's exact opposite. You must actually use it. Agreed?
Chair, I've described what it meant to me or what it means to me.
Mr. Kekana, please answer the question, man.
What is the question, Council?
is that what, where it says use written submission of SSA, whatever it means and whatever you cannot recall, whatever, but what you can tell just from reading, using your eyes, is that it does not mean that you must conceal the interaction with SSA.
Well, Chair, there's nothing there that says conceal.
Thank you. And then at the bottom, it says amend the constitution to cater for State Bank per Goodson proposal to curb future such occurrences by banks. That one speaks for itself. In other words, you are saying the issue of the amendment of the constitution per the proposal of the economic expert, Mr. Goodson. That one seems to be clear. Do you agree?
Yes, that's what she wrote.
Yeah. And if you go back a little bit to 4.2.5, you'll find this is the one that she's being crucified for by the powers that be.
Yes, I'm there.
Well, she wrote there, amending constitution for South African Reserve Bank to benefit the people. Is there anything wrong with that, with making a constitutional amendment to benefit the people of South Africa, as opposed to sectional interests and those who have money and control of the media?
Well, I'm not so sure whether you're asking my view or an opinion, or you're asking whether it was factually right or wrong for her to put that. Can you clarify, please?
No, I'm saying, is there anything wrong in your estimation, Mr. Kekana, as a citizen of South Africa, in amending the constitution to benefit the people?
Well, as a general statement, it wouldn't be wrong, but in regards to the investigation that we're having, for me, it was not a relevant issue.
Yeah, for you. All right, but okay, let me put it this way. As a South African, you are aware, are you aware broadly of that there's something called the Zondo Commission?
I remember the Zondo Commission, not that clearly though, but I do remember the Zondo Commission.
Sorry, okay, sorry, Mr. Okay, yeah.
Yes,
okay, well, no, that's fine. We will, when you and I are having lunch, I'll tell you what is the Zondo Commission. But in case for the part that you remember, do you remember that, for example, Judge Zondo suggested an amendment of the Constitution for to provide for direct election of a president?
Sure. I don't remember that, unless if you show me that. No,
that's fine. Don't worry about it. But anyway, you agree that an investigation that has specific terms of reference, there is nothing wrong in principle for it suggesting an amendment of the Constitution if you ignore the noise from those with vested interests.
Sorry, can you repeat?
In other words, okay, let me put it this way, Mr. Kekan. To amend a constitution is not a crime. Do you agree?
Yes, it is not a crime. It has its own processes that has to be followed.
Correct. In fact, the Constitution itself provides for its own amendment. So there's nothing really alarming about a proposal. People make proposals about bringing back the death sentence and all sorts of things all the time, and they don't get jailed or crucified or impeached. Correct?
Well, maybe to respond to you, this was what the PP wanted to do, but for myself, I didn't see any relevancy in regards to our investigation.
No, that's fine. That's why you're not the public protector. I'm saying that the public protector wanted to amend the constitution to benefit the people. And you and I agree that there's nothing wrong with that.
Well, I'm not so sure. She did write there that amending the constitution for SARB to benefit the people, but I'm not so sure how. But it was
Yes.
there. That's what she wrote.
No, that's fine. Thank you. Right. Now, let's go to the meeting with the presidency. You accept, this one is quite easy. You accept that again, apart from the hullabaloo, there was, that meeting was the meeting of the 7th of June in particular, Mr. Kekana. That meeting was requested by the legal department of the presidency.
I wouldn't know that.
You can't dispute it.
I have no knowledge at all of that.
Right. But what you can confirm is that that meeting only dealt with the issue of the SIU. In other words, the practicalities about the SIU proclamation that the public protector had in mind.
Well, I didn't know about that meeting, and I was invited to it. And when I went there, I saw the meeting had already begun. There were discussions already, and the PP indicated to me that the people from the presidency were there to assist us with the remedial action relating to the SIU.
You did not yourself witness that?
Sorry, I didn't witness what?
You are saying the PP told you, you arrived after the meeting had already happened, and the PP told you that there was discussions about the SIU. So I'm asking, you yourself did not witness such discussions?
No, I'm saying that when I entered, the meeting was already ensuing, meaning that it was in progress already, not after. It was already in progress. And when I entered, I was told that I was introduced to, I think, 2 persons from the presidency. And I was told by the PP that they were there to assist with the remedial action relating to the SIU.
Yes. So you did
I was present. I was present in that meeting, but I didn't start with the meeting.
Yes. Okay, Mr. Kekana. Let's assume you found the meeting halfway or quarter way or whatever. But for the part that you were present, the discussions were only about the SIU, correct?
Yes, they involved the SIU assisting us with the proclamation or the reopening of the proclamation.
Yes. And there was nothing wrong with that discussion. You did not find it odd?
I did not find it normal also, because I didn't understand why we were getting assistance from the presidency's legal advisors.
Okay, and you're saying until today, you did not know that that meeting was not initiated by the public protector, but she was invited by the legal department in the presidency?
Well, I don't know who initiated the meeting.
Right. Well, because the impression is created that she was doing something that needed to be hidden. You wouldn't go along with that because she disclosed that discussion in the report. isn't it?
Well, apart from my view that I didn't understand why the presidency were assisting us with the remedial action relating to the SIU,
Yes.
I really can't comment on any other issues that you are raising.
Right. And also, you may assist us, because then we won't have to call President Zuma. There is a suggestion that the meeting was with the president, and the president at that time was President Zuma, and he does not seem to know of such a meeting. Can you confirm for this commission that you are not aware of any meeting with President Zuma?
No, I never had any meeting with President Zuma.
Yes. All right, just a minute. Because the independent panel, well, the panel that was independent, the says, Chairperson, at paragraph 263 of the independent panel report, that there is prima facie evidence of misconduct against the public protector for the failure to reveal in her report and subsequent affidavits the fact that she held meetings with the SSA and the president. So firstly, we've already established that she never failed to report. In fact, she asked you to reveal the interactions with the SSA and the product thereof. But you can definitely tell the commission that she cannot be accused for failure to reveal a meeting with the president, because there was no such meeting, at least that you know of, correct?
Chair, as I indicated, I've never had a meeting with the president.
Yeah, well, even the National Prosecuting Authority seems to have the same idea, because since the beginning of 2021, she has been charged criminally, and one of the charges is that she concealed a meeting with the president. You are not aware of any such thing?
I'm not aware of any meeting with the president.
Yeah, well, thank you. Welcome to South Africa. All right. Do you, just at a general level, do you understand that the work of the public protector will always be the subject of unnecessary attention from powerful forces in society? In other words, you always have to be vigilant as the public protector as an institution. Would you accept that as a general statement?
Chair, I don't understand the question. Maybe can council elaborate on these forces that we're talking about?
Yes. Have you ever read the judgment of economic freedom fighters versus the speaker, otherwise known as the EFF Nkandla judgment?
Yes, I read that some time ago.
Okay. When the court there refers to the public protector as the biblical David against the Goliath, and talks about those who are in the raw chambers of power who will want to sabotage her. Is this the first time you hear of such a thing?
I remember that as well.
Yeah, okay.
In the judgment.
Yes, that's what I'm talking about. And therefore, do you think that in the midst of that, it is correct or it's proper for the public protector within its ranks to have people who are peddlers of gossip and stolen information?
I don't understand the question. Can you repeat that, Council?
Would you agree that given the onslaught by powerful forces, economic and political, against the public protector, it would be improper for it to harbor within its ranks liars, imposters, and people who gossip and peddle information that does not belong to them?
I wouldn't be sure of that sentiment that the public protector as an institution would harbor negative people or people of no character. All the people that I knew there were of good character.
Yes. And yeah, I'm sure that those ones are still there. Okay. Now, there was the issue of you were also trying to insinuate something about the lawyers, the change of lawyers. You don't know why those lawyers were changed, correct?
Yes, I don't know.
Okay, thank you. That's a quick one. All right, so let's move to the note. You read the note that you wrote of the meeting of the 3rd of May. I had said must be sent to you overnight for fairness.
No, it wasn't sent to me.
Advocate Bauer.
I thought it was.
Okay, sorry, Mr. Kekana. It's quite a short one. If you want a few minutes to have a look. Sorry, it was an oversight, Mr. Kekana. Can you just, it's literally half a page. Can you run it up? Look at it, Mr. Kekana. I'm sure you remember it now.
Yes, I recognize the note.
Okay, good. Is that your handwriting?
Yes, I think that's my handwriting.
Okay. Okay, through this note, I'm going to demonstrate that nothing that comes from your mouth should be taken as evidence that should be taken into account by this august committee. For two main reasons. One is what you called impaired memory, where you just don't know what happened. The second one is just your dishonesty, which I think you've displayed more of. But let me tell you why I'm saying this. I asked you yesterday about what happened in that meeting, and everything that is in your own note, you either disputed or said you don't know that it happened. You remember I asked you that when you were saying they were talking about apartheid times, I said they were even talking about current times, and they were talking about the Heath Commission. You remember that?
Yes, I remember those questions.
Yes. Now, can you see in your note that contrary to what you're saying, actually there was a discussion about Heath, which is current affairs, not apartheid time issues.
Chair, as I indicated, there was no discussion on Heath. My recollection, and upon seeing the note, that there was a reference made to Heath, but there was no discussion about Heath.
Okay, so, but when I asked you yesterday, you did not say there was any reference to Heath. In fact, I was raising that in the context, Mr. Kekana, of demonstrating to you that the issues that were raised, or rather disagreeing with you that the issues that were raised only dealt with apartheid times, or actually even dealt with apartheid times. You remember the context in which I raised the Heath issue?
Maybe you can refresh my memory, but Chair, what I indicated was that most of the discussions were around the apartheid era. I do see in my note that I mentioned Heath, but there were no discussions on Heath. If I remember correctly, there was only just a referral on Heath and Davis, and yeah, but there were no real discussions on Heath and Davis.
Okay, well, whatever you call it, Mr. Kekana, whether it was a referral or a mention, that's exactly what I was saying to you, that those are indications that the issues that were raised were current issues. Davis and Heath are not pre-democratic era institutions. Those are post-apartheid institutions, if apartheid is gone.
Well, if you put it in that context, I would agree with you.
Yes, you agree with me today because your note is here. And I want to also tell you that you also on the South African Reserve Bank, in fact, that's where this question came from. Because you were denying that there was a discussion about the vulnerability of the Reserve Bank currently. You were saying, no, the discussion was about vulnerability before.
Yes.
That's how we, okay, that's not true either.
Can you
look at, look at your note under SARB. Sorry, can you move it down a bit? Furthermore, yes. So the Reserve Bank was mentioned and discussed, correct?
Yes, it was discussed, but as per the context that I had indicated yesterday.
Yes, but look at the second note there. It says, how are they vulnerable? The South African Reserve Bank, yes. That is, the word are is present tense, isn't it?
Yes, it's a present tense connotation.
Yes. So how are they vulnerable cannot be a reference to the apartheid times, or at least the times before the political freedom, before the elections, correct? Is how are they vulnerable now?
Chair, upon reading the statement, it may seem that it was a current sort of proposition, but from what I remember, Chair, we talked about the South African Reserve Bank in regards to the apartheid era.
And you wrote about, you're lying now, Mr. Kekan. You wrote about it in the present tense, although you are talking about it in historical terms. So it's like you say, how is Jan van Riebeeck arriving today? What is that?
No, Chair. As I indicated, Chair, if my memory serves correct, all the discussions that we had on SARB were in regards to the pre-democratic era.
Okay, so must we rely on...
That's my recollection of the events. Remember, Chair, I was present, and I would recollect more than anyone else, especially it would be me and the PP who would have maybe different versions, but that's my recollection of events.
Yes, but Mr. Kekana, I represent the public protector. Do you understand that as a lawyer?
I do understand that.
Okay, now I'm telling you that the recollection of the public protector is the same as that reflected in your own note, that there was a discussion about how are they vulnerable now.
Yes.
That's the public protector, not me, who records that. And that her version is confirmed by your own note. Your version is against your own note. Can anybody rely on anything that comes out of your mouth after this display of the past 2 days by you, Mr. Kekan?
Chair, as I indicated, my recollection of SRB, and especially the discussions, were around the pre-democratic era.
Yes.
How are they vulnerable? Might also have been a question that I was asking as to why or how they were vulnerable. But what I remember the discussions is that the discussions emanated in the pre-democratic era.
I see. Well, okay, two things about that. So firstly, so it's either the public protector and your note are wrong, but your evidence before the committee is correct.
Chair, I'm indicating what I can recollect.
All right. Well, that's fine. I think that speaks for itself. But I think the most important thing you've just said is that the words, how are they vulnerable, might have been a question you were asking yourself. Is that correct?
It could have been possible that that was the question that I was asking myself, or a statement.
Yes. Thank you. Thank you, Mr. Kekana. You see, the problem with this, Mr. Kekana, is the following. The High Court, to your knowledge, and the full court, and the Constitutional Court, and now this committee have condemned the public protector. They've asked her to pay personal costs and
sorry, Chair,
yeah. Now just hold, Mr. Milam. Advocate Mpofu, I was just about to come. I would want you not to speak on behalf of this committee, because we have traveled this journey that this committee has not condemned anybody, including the public protector. Please don't place that in the way of this committee.
Okay, that's fine. Fair enough, Chair. Not yet. Yeah. What I'm saying is that the independent panel has made a preliminary finding. The Constitutional Court, the majority of the Constitutional Court, has found that she was biased, and a litany of epithets that are associated with how unsuitable she is. And the courts have done so. Maybe this committee has not done so, although some of its members have. And some of the parties represented in it have. The point I'm making is that one of the key issues that have attracted such condemnation, insult, trauma to the public protector is because she was accused of having discussed the vulnerability of the Reserve Bank. And now you are telling us that that might have just been something you were writing to ask yourself a question. Do you think that is fair, Mr. Kekana?
Chair, maybe just get clarity, what is fair?
That a person who is a defender of the people of South Africa is crucified, and to the extent of having to pay personal costs for, among other things, a note that you were just writing to yourself about the vulnerability.
Chair, I don't have a view on that. I'm not so sure as to how all these people that council is mentioning arrived at the conclusion. All that I remember is what I have testified on the note.
Yes, let me assist you. In the case of the Constitutional Court, the judgment of Hampepe J, which is the one case where the Constitutional Court upheld punitive and constitutional damages punitive and personal costs against the public protector. Fortunately, there was a dissenting judgment of Mukweng CJ, which went through the issues and with which we agree. But the majority judgment, which is one of the judgments that has brought us here, that Ms. Bauer referred to, says the following at paragraph 178. The record contains handwritten notes of a meeting. That is, those are your notes, Mr. Kekana, the ones that we are dealing with now. Okay?
Okay.
Yeah. Held between the public protector and the State Security Agency on 3 May 2017. These reveal that the vulnerability of the Reserve Bank was discussed. That also comes from your note. You understand?
I understand.
Yeah. The Reserve Bank contended that this discussion with the State Security Agency about the vulnerability of the Reserve Bank was irregular. It said, it is unclear on what possible basis the vulnerability and vulnerability to whom of the Reserve Bank was relevant to the public protector's investigation into the CX report. The Reserve Bank expressed its concern that this discussion appeared to be aimed at undermining the Reserve Bank and so on and so on. But the culmination of all this is that the public protector was biased and her model was flawed and she deserved to be mulcted with personal costs. I'm saying to you, is it fair that she should be visited with all those calamities on the basis of a note that you say you might have been writing to yourself?
Chair, as I indicated, according to my knowledge, the vulnerability related to discussions with the SSA during the pre-democratic era. I don't want to have a view on the Constitutional Court's judgment.
Yes, and even if you are correct, even if it was about the apartheid era, it would make it double unfair for her to be condemned as if it was discussing the current situation, wouldn't it? In fact, if your version is correct, then the unfairness would even be more patent. That's why we're here. We're here because of these findings of the courts, which, according to some people here, they are not to be touched, even when they are clearly wrong and based on the incorrect information, like we have now demonstrated.
Chair, I have indicated a view. I don't have an opinion on the constitutional judgment on that score. And I've already indicated the context of vulnerability of the South African Reserve Bank in my notes.
Right. Now, you were trying to paint the public protector as being responsible for what you perceive as the lack of quality assurance on the report. Is that correct?
The CX report, you mean?
Yes, sir.
Yes, sir.
Whose responsibility was to quality assure the report?
Mr. Isaac Matlawe at that time was in charge of that.
And if he did not quality assure the report, whose fault was that?
Well, if it wasn't quality assured, I think he would be himself responsible for doing that. And if there was a failure, then the PP would ultimately deal with him.
Yes, but the PP asked you and him and all the others to quality assure the document, didn't she?
No, I did the first level of quality assurance because I was the one who was writing the report. But as one knows, you can't really quality assure your own work. So it had to go to quality assurance to Mr. Matlawe to do that. And thereafter, the PP had to also do her own assurances to make sure that the report is in order.
Yeah, but the PP's evidence will be that she said to you that she thanked you for the good report and then said you needed a third person to look at it with a different eye, suggesting Mr. Matlawe. That was an instruction to you for the quality assurance of the report, wasn't it?
Yes, Mr. Matlawe, as I indicated, was the one who was responsible for quality assurance. So usually all reports would go to him before going to the PP for the final check.
No, Mr. Kekana, don't dodge the question. I'm not talking about usually. I'm saying specifically in this case, the public protector thanked you for the report. That will be her evidence. And she said you needed a third eye to look at it, Mr. Matlawe, and that you needed to go through it page by page with that third party.
I can't confirm that. Can you show me maybe that email that you're referring to?
No, why do you think it's an email? Who said anything about an email? It's because you know you received such an email.
No, I'm thinking you're referring to a document or instructions I got by email. So that's why I'm asking.
No, you are right, by the way. It was an email, but that's exactly because you know that what I'm saying is true. Forget about the email for now. I'm asking, do you deny that the public protector thanked you for the report and asked you to have it quality assured?
As I indicated, Council, if you can show me that note, that would refresh my memory greatly.
Yes, no, I'm going to do that, but I'm asking you independently of whatever. Let's assume it was she was just saying it without evidence. Would you dispute it?
Independently, Chair, I have given evidence that what would happen is that the report would go to Mr. Matlawe, and then it would go to the PP for the final check.
Mr. Kakan, please, I'm asking you a simple question, sir. You've just said that the fact that there was no quality assurance must be blamed on the public protector. I'm showing you that it must actually be blamed on you if it was even true. And I'm asking you a very simple question, sir. Do you dispute that the public protector specifically asked you to, having thanked you for the report, to ensure that it is quality assured by Mr. Matlawe? Do you deny that?
I don't remember, but I would have been sure that I would have been the one to quality assure it, and Mr. Matlawe would have been the one to quality assure it as well as the PP as a final check.
Mr. Kekana, do you not understand the question, or are you just...
Maybe you can expand on the question, because I don't feel I'm dodging the question. I'm answering it.
All right. Okay. No, I was just doing this so that you don't, I'm not ambushing you. Chair, I don't know how to deal with this, whether I should send the email to Ms. Bauer and then we can deal with it at another stage, or I can just read it out and put it to the witness and he can deny it or not.
Yes, Advocate Bauer.
Mr. Mpofu, you should send the email. My email is not working, but send it to Advocate Mayosi.
Okay.
Send it, but in the meantime, please read it out.
Thank you, Chairperson. I will make sure one of my...
Get the email earlier today.
Pardon?
would have been appreciated, Advocate Mpofu, if we'd been sent the email earlier today.
Okay, well, I'm not going to repeat what I said in the morning. I didn't know that the man was going to deny his own email or the message. Normally, I don't have to prove. I would have just put it as something from the public protector, but I was not going to know that he's going to deny. But I'm not a prophet. Yeah. So, okay, this is, it says the following, Mr. Subject, draft report. Thanks, Tebogo. Thanks, Tebogo. Very good report, but we need a third person to look at it with a different eye. Bracket, Matlawe maybe, close bracket. And it is a response to your message, which you sent, Mr. Mukekana, to the public protector at 5:06 p.m. on the 17th of May, 2017, where you said, "Hi, PP, kindly find attached a draft working report. I'm not done with it yet, especially," and then number one, research on case law relating to accountability and state money, and something else. And then her response is what I've read to you. Does that refresh your memory?
Can I see that, Council? I really need to see the documents that you're referring to.
Yes.
Especially
yeah,
to jog my memory very well, you know. So
yeah, no. Fair enough, Mr. Kekan. But from just without seeing it yet, does that ring a bell to you?
As I indicated, I had to do the QA on the report. Matlawe also had to do the QA, and also the PP had to do her own QA.
Advocate Bauer, we've just sent it to your WhatsApp. I don't know if that will assist.
Proceed, Advocate Mpofu.
Yes, and I just cannot find the page, Chair, but we actually think that the evidence leaders have this email, but I stand corrected. I'll try and find it in the record. So it might be part of something else. I'm not blaming them. I'm just saying it might be in their possession. All right.
Advocate Mpofu, would you mind if I send it on to the witness as a WhatsApp?
No, I wouldn't. Oh, that might be an efficient way of doing it, yes. But will you also be able to screen share it for the members?
Just give me a minute.
Okay.
Sorry, Advocate Mpofu, while we're endeavoring to do that. Can I understand you to say that this was the PP's version on an instruction given on the final draft?
No, why would I say that? I said draft report. I've read the word draft report twice. I'm saying the subject was a draft. Kindly find attached a draft working report. That's what I just read out. I'm not done with it yet, especially the research on case law relating to accountability and statement and so on. And then the response was, thanks, Tebogo, very good report, but we need a third person to look at it with a different eye. One does not quality assure a final report. You quality assure the one that is on its way to becoming called that. It would be futile to quality assure a report that's already final or issued. That's not what I said. Have you got it, Mr. Kekana?
I do see something, yes.
Oh, good. Okay, your version is even better than mine.
Yeah, just expand it on the screen, if you can. Not possible? Okay.
Thank you, Chairperson. Can I ask questions now on it? Looks like everyone, it's up now. Yes, thank you, Chair. Please remove that. Yeah, thank you. Okay, Mr. Kekana, it's from Tebogo Kekana, 17th May 2017, 5:06 p.m., as I said, to Busisiwe Mkobane, bracket protector, subject draft report. Hi, PP, kindly find attached a draft working report. I'm not done with it yet, especially one, research on the case law relating to accountability and state money. It was taking too long and I wanted to provide you with a complete working document. 2, I've factored PFMA, but realized that I can't make findings on it. 3, I also included short summation of Mboweni, Marcus, Ramos. 4, I also included what the King 3 report, and then it goes on. Mboweni, Marcus, and Ramos, those are economists, Mr. Kekana, correct?
I'm not so sure of their qualifications.
Do you know Mr. Tito Mboweni?
I knew Mr. Tito Mboweni was a former minister, later governor of the Reserve Bank, and again minister, but I'm not so sure about his qualifications.
Okay.
And, yes.
He's Mr. Tito Mboweni is an economist. And Ms. Ramos is also an economist. I'm not so sure about Ms. Marcus, but I think she also is one. But anyway, let's put that aside. If you don't know, you don't know. Your response was, the public protector's response was, thanks, Tebogo, very good report, but we need a third person to look at it with a different eye. Matlawe, maybe. That's the part I'm talking about. Do you still say that she did not ask you to have it quality assured?
No, I didn't say she did not. I said I couldn't remember that. Anyway, I said naturally I would quality assure the report. Matlawe would, and she would do the final quality assurance.
Yes, but I'm saying that you accept that from this evidence, your assertion that she must be blamed for the lack of quality assurance, if there was such a lack of quality assurance, is baseless, correct?
No, my indication is that the report was not quality assured before she released the final report.
Okay, it was quality assured at this point when you were asked to ensure. Did you follow the instruction to have it quality assured?
Yes, I quality assured it. I don't think Mr. Matlawi quality assured it, and I did warn the PP that, and especially before we released it, that the report was not quality assured by Mr. Matlawi.
Mr. Kekan, I think you are now talking in circles. Was the report quality assured at any stage?
I just indicated that I did quality assure it.
Yes, so anybody who says that the report was not quality assured as a general statement would be lying, correct?
Well, I wouldn't want to put it in that way. My answer to that would be that if something has been quality assured in a formal sense, it would have gone to the quality assurance unit, which was by then responsible of Mr. Matlawi. So if a report had been quality assured, it would have gone through QA. There would be preliminary quality assurance by investigators, line managers, but the general practice was that a report had to go to the quality assurance unit before it can be publicized or before the PP signs and does her final checks.
All right, okay. Well, anyway, let me tell you that the evidence of the public protector will be that the report on her instruction was quality assured at all the stages. And in any event, it would be ridiculous for her to say it must be quality assured at this stage and then later not want it to be quality assured. But that will be her evidence. If you care to comment, you may, but that's, she's going to disagree with you.
I disagree that it was quality assured at all stages.
Yeah, that's fine. Now, sorry, Chair. Okay. Thank you, Chair. Mr. Kekan, let's deal with quickly with the Friday Dairy report. You did not participate in this process up to the end, correct?
No, I didn't participate until the end.
Yes. Okay. Let me just, I'll just put propositions to you about the version of the public protector. That she denies that she, anyway, this is third-hand information anyway. You yourself have no evidence of the public protector saying that the investigator should be removed because she was a DA member, correct?
Yes, as I indicated, I was informed by Mr. Ndo.
Okay, well, the public protector denies that, but Mr. Ndo maybe will be called. We'll deal with it with him. But I'm asking you just out of curiosity, if the public protector had said that the person should be removed because they are a DA member, would there have been anything wrong with that?
Well, if there were just statements without any proof, yes, there would be some kind of something that would be wrong about that statement.
Some oddity. Yeah. Any proof of what? No, let's assume there was proof and she was a DA member. There's nothing wrong with being a DA member. Let's say she was indeed a DA member. I'm saying, would it have been wrong to remove her from this investigation?
Well, if she was a DA member, or any other political member, I wouldn't think it would have been wrong. But just, I think on the mere fact that one subscribed to a certain organization and is removed due to that, I think, yeah, that would be wrong.
Have you read the Friede Dairy report?
I tried to. I tried to at the time it was released, but I didn't have an appetite to read the whole report.
Yes, but the reason why you put this issue on your so-called protected disclosure was because you were suggesting that there's something wrong with the alleged removal of the person because they're a DA member. Can I read you the first page of the Friede Dairy report? It says, the complainant is Mr. R. Jenkelson, a member of the Free State Provincial Legislature representing the Democratic Alliance. Now, given that fact, would it have been appropriate to have someone who's a DA member and associated with the complainant to participate in such, or not necessarily DA, anything? Let's say it was the UDM, was the complainant, and you had the investigator being a member of the UDM. Do you think that there'd be something wrong with the head of an institution intervening in that way?
My view and what I knew of Ms. Erica Cilliers was that she was a person of integrity and who did a lot of good work. So whether she was a Democratic Alliance member or not a party political member of any party, I still believe that she did the good work in the Friede report, and I wouldn't think that she would do anything lesser, even if she was a Democratic Alliance member.
Okay, well, that's your view, Mr. Kekana. But do you think that the broader public of South Africa would be comfortable with somebody who was investigating their own case, so to speak? Do you know anything about recusal, about the law of recusal? That it doesn't, you don't necessarily have to have an integrity. If you are a member of the body that is complaining or being investigated or associated therewith, or a spouse of a person who is associated thereof, then you are ipso facto conflicted, even though you yourself might be a person of integrity. Is that incorrect, what I've just said? Did you study administrative law?
Well, if there was a conflict of interest and there was evidence of that and it was proven, I wouldn't see anything wrong with the PP removing Ms. Erica Cilliers because of that conflict of interest.
Thank you. And you understand that conflict of interest is not just actual conflict of interest, it's also what is reasonably perceived. In other words, at an objective level. So subjectively, the person might be the Pope or whatever, but if there's objectively speaking an investigation into the Catholic Church, then the Pope should not be the person who does it at an objective level. You understand? The point I'm making is that it has nothing to do with the integrity of the person subjectively. Do you know that?
I'll accept your view, but I don't have knowledge of that off the cuff.
Didn't you learn it at law school?
I learned it.
Okay. Is it different from what I've just summarized to you?
I would have to revisit what I have studied.
Yeah.
Off the cuff, it becomes very difficult to just regurgitate all that one has learned.
Mr.
Thank you, Mr. Kekana. Thank you, Advocate Mbofu.
What did I do, Chair?
Just listen to the chair, please.
Okay.
We are now going to, it's 10 minutes past 1. We're now going to
adjourn for lunch and come back at 2. And I will return the 15 minutes we might have interfered with of yours before when we came back from tea time. I'll give that to you to come back and wrap up your cross-examination. As I indicated in the morning, we'll do up until lunchtime, but we'll come back and ask you to do a wrap-up session in that regard. So I want us now to pause and go for lunch and be back at 2. Advocate Mpofu, Mr. Kekane will return at 2. Thank you, members.
Thank you, Chair.
Recording stopped.